Ways and Means, so we are picking up H 472, an act relating to professions and occupations regulated by the Office of Professional Regulation. We've already had a walkthrough on this bill, and we have folks from the Secretary of State's office to discuss this with us, and then we have Ted from the Joint Fiscal Office talk to us about this, and the folks from the many massage therapists want to talk to us about this bill. And we have one representative from them coming to join us as well. So with that, would the two of you like to join us, or one of you?
I think it's just
okay, great
because of the configuration, but
thanks.
For the record, Lauren Hibbert, Deputy Secretary of State. And I do want to point out that I have Mike Warren, who is the interim director of the Office of Professional Regulation, in the room. And I may turn to him if I need to, but I wanted to make sure that he was here on this very important bill. So thank you so much for having me come and testify again. I did come last week on Thursday and started to talk about some elements of the bill. And I thought it might just be helpful to go through again the sections that are raising a fee or adding a fee, or where policy decisions will have an impact on OPR, a fiscal impact on OPR. So we talked about section 1. The majority of my testimony on Thursday was about section 1, which allows for the Secretary of State to charge for data feeds provided to third parties. And that fee, again, would be established by policy. There will likely be a difference in a fee for setting up a feed versus maintaining a feed. And it may depend on how many times the feed is being used in a day, a week, a month, a year. Those are the variables that we are thinking about. Happy to talk more about that if anyone has any questions. Okay, section 2. Section 2 is making changes to 3 VSA 125. Again, the goals of this OPR bill are not to raise any fees on any individuals, but to charge for things that we have currently do, or for free, or to increase the fees for things that we currently do. And again, the backdrop of this is that the OPR budget is at a deficit. We're at a better deficit than we have been in recent years, but we're still at a $1.5 million deficit. So we were looking for places where we could generate revenue for things that we have done previously for free or at a very low cost. So the first one is license verification. Anyone can look up licensee's status on our webpage anytime for free. But what this is the printing and mailing of an official verification. It's requested by a licensee, and it's usually being sent to another state. So currently that fee is $20. We're asking that it be made $30. This is something that happens in our office every day, but this is so that someone can go obtain licensure in another state. The second is 3 VSA 125 B4W. This reestablishes the electrology fee. There was a fee bill in 2022, and we moved fees from Title 26 into Title 3, and raised fees, changed fees. In that process, we dropped the electrology fee renewal. They renew in actually, I believe that happened in 19. They renew in 20 in even years. And as a result of not that fee, we have not been charging them a fee for now 2 renewal cycles. And we would like that fee to be reestablished in the law so that we have clear authorization to charge the fee. We have looked at
one question.
Oh, sorry.
Can you just, we were told this last time, I just don't remember. What is an electrology shop?
Sure. Electrologists are people who do hair removal, either with an electronic probe or laser. And the shop is required to be licensed as well under the law, because we need to have inspection authority over the shop because of the types of equipment that are in electrology establishments.
So the electrologists out there
Yes,
themselves, they've been paying their fee?
the electrologists have been paying their
This
fees.
is
Yes,
the shops.
this is recreation of the electrology shop license,
Which we deleted accidentally.
which we deleted accidentally.
And was it 200 before?
It was not 200 before. I believe it was 160, but we looked at what it should have been and what we had changed at the time, lots of fees to increase them. And this is what I think we were looking for. And of course, that was a long time ago now in terms of inflation and several years ago now. It also is in line with similar establishments, barber and cosmetology, tattoo establishments. B9 through 11 are new fees for services that OPR currently provides for free. So B9 is a fee for an apprentice application. So at OPR, we have really focused on multiple pathways to almost all of our professions. We received a federal grant that really emphasized us doing this, along with a lot of other really important work that I'll talk about in a little bit. One of the key focuses is, are there ways that people cannot go through formal education and instead pursue an apprenticeship so that people don't have to take out student loans, people can work and be trained simultaneously. So we have apprenticeship pathways in as many professions as we can, everything from barber and cosmetology, tattoo, funeral. We created an apprenticeship path for funeral, which is probably our most complicated and most creative solution. We came to that with the Funeral Association because it's not a funeral school in Vermont. So people who want to become funeral directors have to travel outside of the state. There is a really cheesy joke about the funeral profession and how we just don't have that many people. It is a dying profession is the joke. But dumb. But it's a very, very important profession for a whole host of reasons. And we need really qualified, dedicated people in this space. So we're very proud of our apprenticeship pathway in that profession, but we have apprenticeships in as many professions as we can. Currently, under the law, if you choose the apprenticeship path, you just pay the application fee. And what this does is adds a $50 fee on top of that. The rationale for adding that fee is apprenticeship applications are considerably more complicated than the traditional pathway because we have to create the apprenticeship. We have a lot more forms and documentation to review. If you went to barber and cosmetology school, we review your transcript and your exam scores. If you take the apprenticeship path, we typically review 1.5 to 2.5 years of supervision documents, make sure that you have covered all of the required things, make sure that your supervisor signs off on your practice over those years, and then that you pass the exam. So it's a much more, in terms of work done by our office, the apprenticeship pathway is more administrative oversight than we have on the traditional pathway. It also is considerably cheaper for the applicant. You did not go to barber and cosmetology school. You didn't incur about $15,000 of student loan debt. And we think balancing all of those variables, the $50 fee for the review of the apprenticeship path is appropriate because it does cost more to our office to have the apprenticeship pathways and to do that more complicated review of the application.
But that seems really cheap for the amount of work you just described.
Yeah.
$50 seems incredibly low. I mean, you must be spending a couple $100 on each application in terms of your office costs.
Yes, we are. We're trying to put a fee on something that we've always done for free. We talked about what those fees could be. We don't want this to be a barrier to a population that we're already trying to reduce barriers for. So we thought that $50 was an appropriate step. Then we'll be able to count how many of these we're doing, how much revenue we're doing. We're also simultaneously paying attention to and documenting how many hours we're spending on each profession in any given day by staff members. So our goal at this moment is to create more data so we can really come to you and say, this application takes this much more. So yes, it is, but we didn't want to, throw a boulder into the pond. We wanted to start talking about the good work, the very important work that OPR has been signing on for free, and start charging money for it without shocking people and without it becoming a barrier.
Is that application fee a one-time fee or is it every year?
The apprenticeship application, it would be a one-time fee, just for that initial review of the application. Yes.
So Michael,
Yes, thank you, Madam Chair. Appreciate that when you started, you said you're underwater and it's getting better, I think you said.
Yeah.
This has been an ongoing conversation here from time to time. I'm just concerned, I mean, I don't have a problem with the proposal, it makes good sense. Almost, I guess I'd say. At what point will you be noticeably out of water? You know, how's it going?
So I wish I could say it's going to be this year. I don't have that answer for you. I wish I could say it would be, 2028. I think by 2028 we'll be in a better place, but the reality is the reason why we were asked to do the funding study for OPR is because the funding model is not sustainable. And so we need to have some really critical conversations in the next couple of years. We did ask for another 2 years. We did file an interim study of our money, and we've asked for another 2 years so that we can gather more data. Essentially, as soon as we started with the task, we felt like we were not getting enough. We don't have enough data about how much our staff are spending on each profession. And so we need that data. And so now we're obtaining it, but we need 2 years of it because of our renewal cycles, because we renew every 2 years. So our work is very cyclical, but it's on a 2-year cycle. And it's very driven by which profession is renewing when. This March will be very different from next March, and that will be very different from next August. So the months are different and the years are different. And so we are doing that. And we also need to have some really critical conversations about the siloed funds. We need to have some critical conversations about the public good that OPR provides that is borne only by licensees at this moment. But we have an entire enforcement division, including law enforcement, that do criminal investigations. They're extremely important to OPR's mission and protecting the public, and they stand at the ready at all times and investigate very serious cases, sometimes death resulting cases, sexual assaults, drug diversions, and the cost of that is borne by licensees. So I am hoping that as we gather more data, we understand the pressures significantly. Interstate compacts are a huge pressure point on OPR. In nursing alone, we lost $1 million of revenue when we joined the nurse licensure compact. Now that was very good public policy, healthcare policy. It was very bad financial policy. And we have done that again and again and again and again, whittling away at our revenue base, but we're still expected to provide oversight over all of the nurses who practice here, whether they have a license in Vermont or not. And we do investigations, serious investigations of drug diversions on our hospital floors of nurses who do not hold a license in this state. And we still are responsible for the review of their conduct here, protecting Vermonters and removing them from practice within our borders. So there's some pieces where the financial model just doesn't make sense. And that's what that's what this body asked us to study. That's what we've started to study. And that's what we're committed to continuing to study. But I do like to just forecast to people that I think we have some really serious conversations ahead about how OPR should be funded. What is the appropriate way that those monies should be managed? Should they be siloed by profession? Should they be pooled? And should we be asking for alternative funding streams? And I thought that was it.
First of all, I want to thank you because I know this has been going on for some time and I really appreciate the systematic effort. And I also know how robust your investigations are and what a valuable service they provide. Do you have discretion around timing? Are you able to smooth your workload
In terms of
when people's licenses come up? Or is there a creep right at the beginning of the year or the end of the year? Is it cyclical or is it something that you can smooth?
we have smoothed it so that we renew every other month on odd months. So we have a renewal cycle that ends in January, that ends in March, that ends in May. We open up the renewal cycle 45 days before the renewal cycle. So people renew, and we have balanced the professions as best we can across the 2-year period. That being said, renewing 18,000 nurses within 45 days is an incredible feat, and we have 2 people doing that. And they're an incredible team. We're able to do a lot of the work that we do because of our IT system. And we've made as much improvements as possible through our IT system, which is another driver of our costs. But if we did not have our IT infrastructure, we would need probably triple the amount of staff that we have. We have 42 people working within the Office of Professional Regulation. And regulating 53 professions, 84,000 licensees and businesses.
A quick follow-up on that. I mean, one of the things that we saw in appropriations was the increasing reliance on travelers was
Yes.
driving extraordinary cost in a lot of budgets. But now I'm wondering if the over-reliance on travelers is also driving cost in your budget. Are you seeing that there are more reviews for nurses than there might have been in a pre-traveler universe?
The biggest impact on us as a result of the compact is that we used to receive revenue from every traveler who had to work who worked in our state. Now, because we do not receive that revenue, it is a revenue hit for us. I will say, we are asked, do travelers have a higher incidence of unprofessional conduct? We have not done that analysis closely, but you could argue it either way. Anecdotally, it does sometimes feel that way, but it's also hard to know whether maybe we receive more complaints about our traveling community because they're not part of the institution in the same way. So their conduct is noticed in a different way or reviewed in a different way than someone who's worked somewhere for a really long time. So I can't say conclusively that traveling nurses have a higher ratio of misconduct than.
I was wondering about just sheer numbers. Are we reviewing more applications for nurses because of a shift in the model?
Because of the compact, we're reviewing less applications, but we do have more nurses in the state, and we're responsible for overseeing the conduct of those nurses in the state,
Okay,
whether we receive an application or not.
that's a good distinction.
Yeah.
Thank you.
Then section 13.
Um,
Did I jump ahead?
yes,
All right,
sorry.
back to you.
B10 in section 2 would create a specialty license. So currently we have licenses and then people apply for specialties on top of that license. We do not currently charge for that. A really classic example that probably a lot of you have heard about, but is not in the law yet, is optometry. They are seeking an endorsement to do advanced therapeutic procedures. That is an endorsement, a specialty endorsement on top of their license. It will be called if it passes, it will be the Advanced Therapeutic Procedures Specialty. So an optometrist would have the base license, which requires work from our office, review of education, exam, et cetera. But then this specialty license will require additional education, a preceptorship, additional coursework, and additional exams. And we think that we should not review that specialty and issue it without a fee. So we're asking for $100 fee to that specialty. There's some other professions that have a specialty in place now that we have not charged it. It would only be charged application, to your question, Representative Higley. It would only be charged at the time of application. It would not be charged on a recurring renewal basis, just when we're doing that additional review of the work. And, I think it's safe to say that, again, to your question, we thought about what this would be. We wanted to make sure that it was rational for people who have lower occupational revenue streams versus higher occupational revenue streams. We settled at $100. I do think in the future, once we have more data, particularly with professions like optometry, we may come to this body and say, this is more than $100 of work. We think this should be an exception to the general rule. And we think it should be $200 or $300. But we were not ready to do that yet because we've never charged for this in the past.
Optometrists already pay a fee.
They do
This is an application for the
for the specialty.
practice. Right?
Yes. And, for instance, psychologist prescribing, They will have a specialty. If you're a psychologist, you pay a fee currently to be licensed. But if you seek the prescribing specialty, then we would charge you this $100 fee when you apply.
And so this is any sort of.
This is, yeah, anything.
Thank you.
So,
Um,
but the examination, and all the other kind of stuff that you're talking about to get the specialty license, what does somebody pursuing that actually spend in order to get that besides a $100 fee?
Oh, multiples of thousands of dollars. Yes.
Okay, so $100 fee is not going to be,
It's not going to be a barrier for the majority of our professions. And for the majority of our professions who are seeking this, they are requesting from the state authorization to expand their scope of practice significantly so that they can provide more services and make more money.
yeah.
So I don't think this is an unreasonable barrier and does a small step to compensate for the work that our office is doing.
I think you should charge more.
I hear you. And I'm not going to tell you I disagree with you. I wanted to start, we wanted to start somewhere that was reasonable and start this conversation and gather more data so that then we can have a data-based conversation, because I just worry if I had said $200 or $300 that would have had an impact on some of our professions in a disparate way. And we really, really, really try to be as fair as we can with our fees. And that may have to be part of the conversation that we have long-term. But I received an email today about nursing fees, and our nursing fees, probably shouldn't say this, but our nursing fees are the highest in New England. And people are really upset about that. And our nursing fees do not cover the cost of our nursing program adequately. So we just have an economies of scale issue. We don't have enough licensees to pay for our IT system that is required to do everything that Connecticut's IT system is required to do. And we have to pay the same amount. So it's just a problem.
And so last biennium, we changed a lot of fees with just sort of regular inflators for the most part.
Yes.
And really tasked you all, and you were very happy for this
Yes, I
process,
asked for it. Yeah.
to look across the entire structure and find a more rational, reasonable way to do this that met the needs of the professions and your office's needs. That is not a project we are taking on here or this session. That is something that you're going to come back to us with a much more holistic report. And this is essentially a stopgap measure for you to get the data you need and the revenue you need to make it to that point.
Yes.
Great.
Yes.
I also want to just sort of flag timing for folks.
I'll speed up.
You know,
B,
We're asking you good questions though, so it's hard for you to go.
it's hard, yeah, and on a topic that I adore. B11 establishes a disciplinary action surcharge of $250. This is a new model for us, and it is happening in a lot of other states. This would be charged if someone is investigated, prosecuted, and adjudicated as having committed unprofessional conduct. And this offsets by, again, a very minuscule amount, the amount of work that we do on those cases. But right now, the cost of those cases is borne by everybody in the profession, and not in any special way by the person who's the target of our investigation, prosecution, or adjudication. So again, this would not be if you were investigated and not found that you may have committed unprofessional conduct. It would not be if you were prosecuted and then found by the administrative law officer or the board that you didn't commit unprofessional conduct. It would just be after you were investigated, prosecuted, and adjudicated as committing unprofessional conduct. This would be something that we would work with people on. We typically, for some of our fees, we give people long runways to pay fees. We would be very lenient on getting these monies, but we are hoping that this will help generate some revenue. And section C of 125 is, it currently said that we would not charge renewal fees during a license lapse. We currently do. And so we would like this section stricken. We should have done that several years ago. Several years ago, we started, instead of if you allowed your license to lapse and you continued practicing, we would always open an investigation and prosecute you for unlicensed practice. Now, instead, we have a fee structure that's set out in 127 that is based on the months that you've been practicing without a license and the renewal fee, and it scales up. That's so we don't have to incur the investigation and prosecution costs and just charge you a fee. And this section of the law should have been redacted when we put that into the law. Section 3 modifies the renewal fee for peer support providers. The renewal fee was intended to increase from 50 to 75 in 27 when we put that bill through. I don't know how it dropped. The application fee did it. The renewal fee did not. It happened. We would like that to be changed. Section 4 is modifying 3 VSA 123. K2 strikes the last sentence. Under that federal grant, we really worked hard on career pathways for people with criminal convictions. One of the key things that we did is we created a second chance determination process, which means before you incur debt to go to school or start an apprenticeship pathway, you can ask our office, will this conviction bar me from being a veterinarian? And we look at your conviction, the facts around your conviction, your signs of rehabilitation, and we make a determination, yes or no, your DWI will not preclude you from being a veterinarian. That decision before you go to veterinary school.
That is so helpful.
It's I love that. We do that. But it's really important because the evidence around rehabilitation, if somebody has a valuable occupation, is able to provide for their family and themselves, they're much less likely to become re-involved with the criminal justice system. And we don't want people to go to nursing school, go to veterinary school, go to accountant school, start an apprenticeship. There's so many pathways that people could go, and then spend all of that time and then realize, oh, I shouldn't have spent that time. So that decision is binding on us. It takes quite a bit of time in our office. We have multiple levels of review, including a prosecutor from our office, our licensing chief, our licensing administrator, our general counsel. They all meet together once a week to go through these applications to make sure that we're making consistent and rational decisions. We have been charging $25 for that review. And the policy had been in 19, when we were in a different financial position, that we would refund that $25 when you ultimately applied. We are asking to not refund that money, to keep that money. Section M is not related to fees, so I'll just I will skip over it, but essentially the boards and commissions law required termination of any board or commission that had not had a statutory change within 5 years. We're asking for an exemption to that law because we're constantly reviewing our boards and commissions, our boards, and also we have sunset and sunrise provisions in Chapter 57 of Title 26. And if we had to change the law every 5 years just to keep the Board of Nursing, there would be a lot of unnecessary legislation before this body. Section 5 raises the administrative penalty for unauthorized practice to $5,000. That is consistent to the penalty when that action is pursued in Superior Court. It's currently $2,500. We would like it to be $5,000. And Section 6 is just providing the authorization to charge the disciplinary action surcharge that we're making in Section 2. We just needed that authorization for the director to do. I'm going to skip over Section 7 and 8 because there's not a fiscal impact and go right to Section 9. We did a sunset report on motor vehicle racing. After our review, we decided that we did not need to regulate motor vehicle racing because the private marketplace insurance is adequate protection. The way that we have been doing it is extremely antiquated, and we are one of only 5 states in the nation who regulate this profession at all. And we are the only one who regulates it in the very prescriptive way that we do.
Do you remember once talking about the embankment?
Yeah.
Yes, great.
And so I bring this up because we are asking for that entire chapter to be repealed and for us to get out of the space, but it does have a revenue loss for us. So again, good public policy, revenue loss. pursue the good public policy. But it does have an impact. And then the last piece is section 12. We are asking for an appropriation and creation of a position. The appropriation that we're asking for is a one-time general fund allocation of $170,000 to create and hire for a mental health executive officer. We recently finished a 2-year study on our mental health licenses. We were asked to do so by this body in Act 117 of 2022 and Act 777 of 2023. We have 17 different types of mental health licenses in our office, and each one of those has multiple pathways into the profession. I think we're upwards of close to 50 different ways to become a mental health provider on a broad definition in this state. This profession is incredibly rigorous. You have to receive a master's degree or a doctoral degree. You have to do supervised practice. You have to take exams pretty much across all of those professions. There is also a wide diversity of education. It is not always standardized. A lot of our rules are very complicated and have a lot of hurdles. Someone who chose to go to a school may not have realized when they applied to school that their school needed to have a class specifically in the DSM, which is the diagnostic training tool for mental health providers. We are looking at the transcript to find out, did you take that class? If you didn't, we reject your application. And we don't have a lot of creative ways around that. So we found that we have some things that we have created that make it difficult to get licensed. We have some things that the world has created that make it difficult to get licensed. And the high level findings is we would like to create a consolidated mental health licensing board. So take 16 of those 17 professions, put them all under one board, streamline the process. The excluded profession is psychologists. They may become part of that board in the future, but we were not ready to move them in right now. So one board, this is going to require, next year, we're going to come with a legislative proposal that will rewrite multiple chapters in Title 26 and be a reorganization on several levels, looking to streamline as much as we can. This will also be major administrative rule making revisions, extensive.
We look forward to it next year.
And we look forward to it next year, an extensive stakeholder engagement. So we really need this executive officer for this profession. We have 2 other executive officers, one in nursing and one in pharmacy. They're really critical for us to be able to move work through as subject matter experts.
Can you remind me what the bill number was that led to all of this?
There's 2 of them. It's Act 117 of 2022 and Act 77 of 2023. Yes.
And then the very final section.
Is massage therapy establishments. This doesn't have an immediate fiscal impact on our office, but will in the future. So I think it's important to touch on. We pursued after multiple Sunrise evaluations of massage therapy. Our office has done 3 in 2010, 2015, 16, and 2019 to start regulating massage therapists and touch professionals, body workers and touch professionals. There was a large push by the profession to be licensed. We did not think that licensing was necessary at that time. We thought that registration of everybody who's in this field was the appropriate level of regulation. And as you folks know, we really try to tailor the regulation to the least restrictive possible. And so that we found registration was appropriate. At that time, we found that registration of the individuals themselves was sufficient. We have now been in this space since 2021. The law became effective in 2021. Since that time, we have been issuing registrations, but we also have been doing our enforcement activities. We have over 24 complaints that we've received. Many of them are professional in nature or are sexual misconduct. We have had, I think, Mike and I were just debating, I think about 7 or 8 significant sexual misconduct criminal where we have taken away massage therapist licenses or we've done the criminal investigation and the state's attorneys are doing the criminal prosecution. We also have received multiple instances of human trafficking. And this is a piece that I have to say, we were wrong in 2019 when we wrote our report. We thought that registering the individuals alone was sufficient. We thought that registration of the establishments would not do anything to help us curb human trafficking. We had not been in the space. We have now been in this space. We are seeing what complaints are happening. Mike is the interim director of the Office of Professional Regulation, but prior to him being appointed to that, his role at our office is chief investigator. He comes to us after 20 years with the Burlington Police Department. He headed up a major investigation, which was publicly written about in Brattleboro, did a massive investigation, worked collaboratively with the law enforcement there, the state's attorneys there. And really, we've been talking a lot about this. We think that if we had regulation over the establishment, had the ability to suspend the establishment, meaning they had to close their doors, we would have been more effective in that investigation. What happened was we all worked collaboratively, the royal we, Mike, worked on this big investigation and the individuals involved disappeared. This is a criminal organization. It crosses state lines. It's the closest to organized crime that I think we probably have here. And we did not have the ability to close the business. So we do agree that regulation of massage therapy establishments is prudent. We were not ready to pursue something this year, but we want to study it. We'll obviously engage with a lot of stakeholders about this and law enforcement, et cetera. But obviously the regulated community themselves, law enforcement and the state's attorney's office and the attorney general's office. But we know that there are approximately 20 illicit massage establishments in this state. At a minimum, if you look at, all the internet sites, you can read about all of the things that happen there. I wouldn't encourage it. And it's quite horrifying. And that's just what we know about. So we want to be good partners with law enforcement. We are law enforcement. And we want to do everything we can to help with this problem. That being said, it will have a revenue impact if we establish a fee for massage establishments. We do not have a preconceived notion of what that is. We don't have a preconceived notion at this moment of which establishments will cover. We have talked about the difference between a solo practitioner versus where there's multiple people working in the same place. That could be an access point, although a lot of our sexual misconduct is occurring in solo practitioner places. So we'll have to debate all of that.
So what I hear from you is that you have done significant work just under the designation of registration.
That is correct.
You've learned a lot from that.
Yes.
You are bringing back to us recommendations next year to move towards another step in regulation, both for individuals and for establishments.
Yes.
And at that time, we will discuss appropriate fees for that.
For establishments, and I assume that we will talk about individuals as well in that context, because we'll want to make sure that we are not creating unreasonable barriers for people to have their own business and work within that business. And that is a different equation if you're on your own versus having multiple. So yes,
That will all be next year.
that'll all be
Does
next
this
year.
still in any way increase fees on massage therapists?
No, it doesn't increase or reduce fees for massage therapists at all.
Thank you very much.
You're welcome. And I do want
A
to,
lot of testimony on our website. I've received an extraordinary number of emails. I don't know if everyone's been getting them. Okay,
Oh, yeah.
okay. There was not a full CC, so I didn't know if everyone else was getting them. So thank you for clarifying where we are on this.
And I just, for context, I just wanted to follow up on something you said, which is, this is of all of the number of licensees, the types of investigations we're doing, I would put them in the top 3 of complicated. Of our professions. Our drug diversions in our nursing space are very complicated investigations. It requires review of medical records, and that's very complicated. Our mental health investigations are very complicated because you're reviewing clinical notes, and there is also in that space, unfortunately, a higher incidence of sexual misconduct and boundary violations. And this is our 3rd most complicated space, which is sexual misconduct and human trafficking. And again, I really cannot emphasize enough how complicated our human trafficking investigations have been. They're financial, they're human horror, they're in multi-agency investigations.
Representative Higley. and
Um,
then Higley.
sorry.
So currently this profession is registered.
They are, yes.
But I think I heard you say that something about licensure. So these investigations, they should have lost registration, correct?
And they have, some of them have, yes.
So that's a way for them to not practice anymore.
Right, but from an enforcement perspective, whether you have a registration, a certification, or a license, we still have to do the same level of investigation. We still have the same standard of proof that we have to prove, and the remedies are exactly the same. Our authorization under the law is to remove you from practice, whether you have a registration, a certification, or a license.
So again, I thought I heard you say the one in Brattleboro, you weren't able to do anything about what?
None of us were, because the witnesses disappeared.
Right, but again, the practice would have been to remove the registration. They wouldn't have been able to practice legally, correct? I mean,
Well, so I think that's an interesting policy thing that we all have to grapple with here. If someone is trafficked, they don't have a registration, or they do, but they are a victim of a crime. So removing the registration from them or charging them with unlicensed practice is not the most effective way to remedy the problem. What we want to be able to do is close the business, shut the business down, so that they can't bring somebody else in. Because what happens is the person is here, we do our investigation, the next morning that person is gone.
how's that going to be any different though if you go to licensure?
I don't think it will be different if we go to licensure of the individual. I do think it would be different if we had jurisdiction and authority to close the business. Right now, we have no authority to say that business in Brattleboro is closed. We did an emergency suspension. It no longer can operate at that location.
Thank you.
Representative Meslin? And
Yeah,
then Representative Kimball, and then we are wrapping.
couple of questions and they may be beyond purview.
Then please don't ask them because we have minutes left in our testimony. But please ask any that are.
Well, I'll wait my turn while I sort them out.
Okay, Representative Kimball.
Just generally, when you're licensing professionals, it's about their qualifications.
Yes.
In this particular instance with massage therapists, it's not necessarily about the qualifications, but about the abuse of the practice. Is that an accurate statement?
In terms of why we're seeking.
Yes.
Yes. Yes, that is.
Which is why the other Sunrise studies did not recommend licensure.
Yes. And the other Sunrise studies found that in states that do require licensure, the vast majority of them have human trafficking occurring within them. So that licensure itself is not a preclusion and does not prevent human trafficking, which is why a piece of why we did not recommend a licensure. We didn't recommend it for a whole host of other reasons as well, mainly that it would have boxed out a lot of people that are currently practicing in our state, Reiki, touch professionals, energy workers. I mean, this is a wide field. We thought that everyone who's working in this space, who has access to people who are unclothed, should be registered. But how do you write the qualifications for that? And we were going to preclude people and exclude people who do have access to vulnerable Vermonters.
Representative Meslin.
Yeah, thanks. Early on, you said that we have the highest fees for a number of things like nurses.
Yes.
In other states, do they have different funding models that we can follow?
Some of them do. That's part of what we're studying.
Okay. That's sufficient for now. Thank you very much.
The biggest factor is the volume of licensees.
Understood.
Thank you, Representative. Thank you very much, Lauren.
Thank you. I'll be available if there's any follow-up questions. Thank you so much.
Ted, thank you.
Of course.
And folks, we might go a few minutes into lunch.
For the record, Ted Barnett, Joint Fiscal Office. So following all of that fantastic context and discussion, I'm going to leap right into a summary table to talk about the revenue impacts as a result of H 472. And to note that within this table, these were fees that we were able to get information for, B, actually forecasting detail on that. So for the increase in verification license fees, we're anticipating an additional $20,000 in revenue in fiscal year 26-27. We're looking at 2 fiscal years here because Secretary of State fees, some of them renew biannually, so you have to look at 2 fiscal years to get a sense of the trend. Reinstating electrology shop adds $3,000 in fiscal year 27. Annual or applications for apprenticeships add $7,500. The big revenue driver here is specialty endorsements. Every year, OPR forecasts that they do 2,000 of those, and with a $100 fee, you're looking at $200,000. And then the repeal of motor vehicle racing would reduce fee revenues by $2,000 in 26 and $14,000 in 27. And so on net, you're looking at an increase in fee revenue of about $220,000 per year for the professional regulation fund. We do not forecast fines and penalties. So the disciplinary action surcharge, the change in penalty for practicing without a license, just general practice that we don't forecast those types of fees, fines, and penalties. And then we do not have data to estimate what the provision that would allow them to charge for data subscriptions would raise, because that's a case by case as needed business or as needed basis. And then would note the $170,000 appropriation in section 12 for the new position. And that's the general high level look at fiscal impact.
Is there any increase in fees for massage therapists in this bill?
There is not.
Thank you very
Yes.
much. Appreciate that.
Of course.
Yes.
Just
Representative
one
Felton.
clarification on the special licensing endorsement.
Mhm.
You have 2,000 units expected.
Mhm.
Where did you come up with that number?
That was information from OPR. And I asked them directly, and that's the information provided to me.
It just seems very high to me.
I don't know if Lauren has additional
Yeah.
context on that piece.
Lauren Taylor for the record, we do issue specialties now to a multitude of professions, not just ones that are coming through. My example was professions, 2 professions that are coming through. But right now, one is a security guard with a firearm endorsement. So if you are a security guard and you seek the firearm endorsement right now, you don't pay an additional fee for that endorsement. You would then pay $100. So that is one of the groups that is part of that 2,000.
All right.
Any other questions? Thank you very much.
Of course.
And our last witness on this bill is Hercules Leotard. Leotard? Great. Thank you for joining us. Welcome to the Ways and Means Committee.
Thank you for having me. I guess my name is really hard.
It's thrilling. Thank you.
I get that a lot. Well, thank you for having me today. As I said, my name is Hercules Leotard. I'm the board member of the Vermont chapter for the American Massage Therapy Association. And more importantly, I am a 36-year veteran of massage therapy practicing here in Williston, Vermont. Thank you for the opportunity to testify on behalf of the AMTA regarding OPR's fees for massage therapists. I do want to stress, I understand the committee is not going to adjust the OPR fees this year. I do appreciate the opportunity to present the information for you to have you consider a fee adjustment in the near future. The level of regulation for massage therapists in Vermont, for the Vermont registration, note we have requested that the profession be licensed, but that the continued discussion of other committee, that's for other committees to discuss. I'm going to stick to the fees in the committee. Despite massage therapy remaining unlicensed practice in Vermont, the high annual fees for registration essentially being placed on the massage therapist registers has placed a significant financial strain on professional massage therapy field. As of today, the renewal is $275, which is the same as, or in some instances, more than other professions that are fully licensed. Social workers are paying $180. Radiology therapists and technicians are paying $175. Cosmetologists are paying $155. Private investigator or security service unarmed registered, who just registered, only pays $95. Records show that approximately 400 massage therapists have allowed their registrations to expire, likely due to the rising cost. We have heard many complaints about these fees. There is a disproportionate financial burden placed on massage therapists. The fees do not reflect an equitable fee structure given the low regulation of registration. Also to note that if registrants renew the registration, OPR will collectively approximately raise $350,000 in renewal for a profession that is not licensed or fully regulated. We ask when the committee considers fee changes that you support that is more commiserate with the level of regulation for our profession. Thank you.
Thank you so much for joining us. I hope you can come back next year or the year after when we do pick up this issue specifically.
Appreciate it.
Thanks for joining us.
Yes, Madam Chair. I would move that we find H472 favorable as presented.
Thank you. Any discussion? We actually don't need seconds on committee motions. Strange new update this year about the way the world actually has always worked, but none of us knew.
Brief comment, but not to divert the discussion further. Appreciate the testimony. And it makes more sense now that we've heard it than it did before we walked in the room. There does seems to be, probably completely unintentionally, a disconnect between simply licensure, registration, and the other things that we've heard about in email that we understand you're trying to get a handle on. Beyond our discussion today, but I thank you for providing an avenue for broader discussion. Thank you.
Madam Chair, I noticed that the bill out of government operations and military affairs was not unanimous. So I'm wondering if anybody could suggest what the concern was with the members that voted no. Was it a policy decision or was it a funding decision?
God, I have no idea. And we're not supposed to ask people on the sidelines questions when we're in committee discussion once there's a motion on the table. But I wonder if it would be okay with everyone from us to make an exception. Okay. I wonder if the reporter of the bill from House Government Operations could join us for a moment. Hello and welcome.
Hello. I was just coming to observe, but glad to be helpful.
That's what happens when you walk in the room. Sorry about that.
The discussion
You could
center.
identify yourself for the record.
Oh, yeah, sorry. Representative Nugent from South Burlington. we discussed the fees and I think some folks were concerned about placing a burden on folks who were re-registering or doing part, the associated activities.
In particular, that piece of re-registration, is that?
Or just the fees in general. Yeah. Yeah.
Thanks for joining us. Okay, back to committee discussion. Any further discussion? Seeing none, if the clerk could please call the roll. Thank you.
Representative Brannigan.
Yes.
Burkhart will vote yes. Representative Feltes?
Yes.
Representative Higley?
No.
Representative Holcomb?
Yes.
Representative Kimball?
Yes.
Representative Maslin?
Aye.
Representative Odie?
Yes.
Representative Lazazak?
Yes.
Representative Canfield?
Yes.
Representative Kornheiser?
Yes.
And we have voted favorably on the bill 10-1-0.
Thank you. What was the bill?
472.
Thank you.
Sorry.
No, fine. Okay, thank you. Yes,
You have someone in mind to.
I don't. Would you like to? That would be delightful. Thank you, Representative Brannigan. Everyone, if you want to take a big breath, we're going to shift gear. Are we not shifting gears? Representative Maslin, we are not shifting gears.
Expecting roundabout, Representative Holcomb and I had a constituent whose daughter was trafficked. Not in this manner, I don't think, but trafficked and died from hopefully. It's the knowledge for the committees, or bring up, let the committee not lose track of the fact that trafficking is all over the place, and we learned today of a new avenue, I guess you could say, to trafficking. It's very concerning.
Thank you.
Just, Ted, at some point, if I didn't ask the witness the question, but to know the depth of the financial hole the Secretary of State's office has, if you have any of that information at some point in time to share with the committee, that'd be great. Not necessarily now.
Thank you. Anything else on this bill? Thank you, everyone. We are going to take a deep breath and stay in our chairs and do our last bill of the morning, which is H397. Tucker, would you like to join the Zoom so you can share your screen? And you're welcome to wherever you want to do that.
Sorry.
I was ready today though, so there will be no laptop hiccups.
Okay, I mean, I don't know if we should say that so soon. Yes. But do you want Tucker to talk us through it, or do you want?
I just.
Yeah, okay.
Thank you.
Wanted me to remind you.
That's it. Thank you very much.
That's all.
Much very helpful. Representative Brannigan, you see your email?
Yes,
Okay.
on my email, Sasha.
Yeah.
Yeah.
Is it flying through the air?
I have joined,
Sorry.
joining,
Oh,
it's coupling.
there we go.
All right, success.
Good.
Tucker Anderson getting better every day. Tucker Anderson Legislative Council. You should see on the screen behind me and potentially on your own screens, draft 2.1 of the committee's amendment to the Government Operations Report for H397. There are just a few changes from what you reviewed yesterday. And I had a list, but now I'm not sure if it's gonna show up on the screen back there and I don't want it to. So the first change, this is something that I flagged during the walkthrough yesterday. There were just some technical corrections. They were necessary in section 6, correcting the section heading, which still had a reference to an appropriation that had been moved to the appropriation section, and also changing the name of one of the positions to an all hazard mitigation technician. The third instance of amendment is also new here for draft 2.1. This strikes out section 12 from the government operations report, and that was the level debt servicing repayment section.
And folks, I want to be clear, I don't think we're objecting to this. It's just that we don't have time to dive into it, and we will have time after crossover when we take up a lot more we're going to take up a lot of infrastructure bill language, and we can tackle it there. If we lose track of it, please ask people to remind me to come back to it. It was just complicated and time is of the essence here.
And I'm sorry.
Again, explain to me what section 12 was again, that you're referring to that we took out.
Section 12 amended the section that governs repayment of bonds for purposes of 24 VSA Chapter 53, Subchapter 1, which is basically all of the bonding and indebtedness that municipalities take out for terms of longer than 1 year.
It's the one where
This affected the
Ted brought up the diagram.
And again, it's being taken out, but we're gonna consider it.
100% and probably pass it. I don't know, but like, yes, I'm not objecting to it. I just want to spend more than 5 minutes on it.
All right, thanks.
The last change does not appear to have been saved in draft 2.1, so I'll show you what it is and send a fresh draft 2.2 to Sorsha and all of you so that you can see it. In subsection B here in the effective dates, it should read section 13B instead of section 10. And it's something that I flagged today as I was doing my final review of the committee's amendment. So I'll make sure that it's the correct section here in the effective dates in draft 2.2, which
Thank you.
I momentarily will.
Thank you. And can you share Representative Wozniak's amendment as well?
Yes. Is it posted on the?
It is.
Yeah.
It's under his name, not yours.
That's how I'll navigate to it so that I don't inadvertently pull up DM live on the air.
Screen sharing is really a very vulnerable thing.
Yeah. Particularly when you're a tech goof like me. There's landmines everywhere. All right. It's under Edward Teddy Trustek. There it is.
Thank you, Tucker.
Like me to describe draft 2.1 of this and what's happening here?
Yes, please.
Same initial proposal that you saw in draft 1.1 yesterday. For purposes of the voluntary buyout program, this strikes the last sentence of that section that requires municipalities to maintain the acquired property as open space in perpetuity, and instead inserts this new language to read: a municipality may, discretionary authority, transfer or redevelop the acquired property for purposes of constructing flood resilient housing.
Madam Speaker, I agree with the amendment, okay? But is this the place for us to include that amendment? Again, doesn't GovOps gonna have to look at this?
They're gonna have to look at all of our amendments.
But again, I thought over the course of the few weeks that we've been here, this is a money committee, not policy, and here we are throwing policy into part of the bill.
So it's the guidelines for what is essentially a tax buyout. So, and I wonder, Charlie, you have a bit of language that I forgot to communicate to Tucker, and I wonder if that actually would help clarify.
Yeah, I was suggesting in section 5 that the voluntary buyout reimbursement program be really retitled municipal grand list supplement support program. Because it's not a buyout program in this context, it's just supporting their grand list.
Yes, what I would propose is still having it mirror the actual name of the program, right? Because it's reimbursing reimbursing tax value that's lost through what is called the voluntary buyout program, which is why the term that GovOps used is the voluntary buyout reimbursement program.
I think maybe the problem is that we're not reimbursing for the voluntary buyout, we're reimbursing for grand list loss.
Just
Whatever title you would like.
Yes.
As I've said before, and so it shall be done. So.
And so Representative Higley, I think the difference is that we're actually looking at the guidelines for something that is about grand list loss. And so it's sort of firmly in our policy jurisdiction. That's why I would see it as different.
All right. Yeah.
I mean, I think this entire section could have originated in this committee rather than in the GovOps committee, and that would have been a very legitimate choice. And frankly, I feel like GovOps got a little too deep into fees on their own this year, but we don't need to get into a full jurisdictional battle with that.
I'll just remember this when I may want to interject a little bit.
Absolutely. Yes.
May I just request that someone sends me the new name or repeats it again so that I can record it accurately? I would love to get this right the first
The
time.
idea would be municipal grand list support program.
Does that feel okay to people?
Yes.
Yes.
Muggles.
No, don't. Representative Feltes, you're making a face at
Well, I'm
processing
thinking
things.
that-
Yes.
I tried to, I suppose that's as good as anything. I mean, I agree that the purpose is to support the grand list. Subsidize the grand, but to stabilize the grand list is what I would call it, but.
Oh.
Build it back.
Municipal grand list.
Stabilization.
Oh, gosh, look at us wordsmithing in committee.
Look at that.
What a nice Wednesday breakthrough. No, you're right though. Municipal grand list stabilization program.
Yeah, that sounds good. Keep
Okay.
muggles.
I was gonna say the acronym doesn't.
Tucker, how does that feel? Inside your typing, are you able to type it? I just mean like, does that work for you mechanically?
You go sit over there to get draft two ready.
Representative Canfield.
Tucker, how many straws are in that milkshake?
What kind of milkshake is
I
it?
was counting yesterday, it seemed like 3 for the.
Okay, so you're gonna make those two quick changes. We're gonna hear from Ted? Is that a plan?
Don't have any.
What will you say to us?
Yeah.
Okay. Have you said officially you have nothing to say to us? Is that what's happening?
I've commented on kind of the previous version, like preface everything that's in Louisa needs to know, so.
And what is your name, sir?
Ted Barnett, Joint Fiscal Office.
Thank you. Would anyone like to hear anything further from Ted Barnett from the Joint Task Force? Okay, we are at ease for 3 minutes.
We have another bill.
No, this is the last thing we're doing before lunch.
Like, so do
All right.
Thank you.
Like that.
Have it after.
Did you want, you know? Tucker, thank you so much for your on the fly. Is that the expression I'm looking for? And I don't think you got enough acknowledgement for the hey honey yesterday. You were seen.
I have often felt seen like drag up some archaic term. Of Skillbots, it was a dram 2 years ago in the context of liquor liability.
A weed ram?
A drop clock, which is also a coin.
That's the dram shop insurance policy.
That is correct. All right, I'm navigating over so that I can share. I promise I am doing meaningful work while I'm talking about antiquity. Just make sure. Sure.
Thank you.
2.2, look at that. For purposes of draft 2.2, you have 3 changes that the committee discussed. First, there is a new first instance of amendment, which contains Representative Wazazak. Is that the proper pronunciation? Wazazak. For some reason on the floor, I heard Wazazak and it is stuck in my brain. Wazazak's amendment in section 3 that we just walked through. In the second instance of amendment, I have updated the name of the program to be the Municipal Grand List Stabilization Program and made sure that that is used throughout this new subchapter 4C language. I did do a Command F search to make sure that there were no more voluntary buyout reimbursement references in this section. The final instance of amendment, and I'm not sure what happened with the PDF that I sent the committee, because as soon as I opened up this document in DM, there it was, section 13B was already in the effective dates.
Thank you.
That's all.
Thank you very much.
Good, thanks.
Representative Wozniak, would you like to make a motion?
Sure, and that would be a motion to find favorable with amendment,
Trying to amend the bill.
motion to amend H 397.
Thank you. Any discussion on the amendment? Seeing none, if the clerk could please call the roll.
Representative Brannigan.
Yes.
I will vote yes as Representative Burkhardt. Representative Feltes. Representative Higley.
Yes.
Representative Holcomb. Yes. Representative Kimball.
Yes.
Representative Maslin.
Aye.
Representative Odie.
Yes.
Representative Wazazak.
Yes.
Representative Canfield.
Yes.
Representative Kornheiser.
Yes.
We have voted to amend the bill 11-0-0.
And then we'd like to make a motion.
Motion to find the bill as favorable as amended.
Thank you. Representative Wozniak moves that we find H for
397.
397 favorable as amended. Any discussion there? Seeing none, if you could please call the roll.
Representative Brannigan.
Yes.
I will vote yes as Representative Burkhardt. Representative Feltes.
Yes.
Representative Higley.
Yes.
Representative Holcomb.
Yes.
Representative Kimball.
Yes.
Representative Maslin.
Aye.
Representative Odie.
Yes.
Representative Wazazak.
Yes.
Representative Canfield.
Yes.
Representative Kornheiser.
Yes.
We have voted the bill favorable with amendment 11-0-0.
Thank you, everyone, very much. See you at 1:15. Yes, Representative Wozniak is going to report it. Representative Wozniak, please don't leave your desk until you forward